Thank you. Ms. Burchell.
For those of us who are in the courts almost on a daily basis, I think the first impact that we really saw with regard to the budget problems was a significant increase, almost double in many respects, to the filing fees that citizens have to pay to even bring their cases to court. And I think that's a problem. Additionally, though, I think I practice in many of the counties in the 10th Judicial District. Anoka County, in a criminal case, you have your first appearance, and then it's upon the defense attorney or the litigants to decide whether or not there will be additional hearings before trial, where other counties just automatically on a felony case would set a Rule 5 or Rule 8, an omnibus hearing and a pretrial, and you continue to show up and oftentimes get continuances, and those things bog down the court systems because there are so many cases on that really go in and do nothing. So I think if there's a good look at how many cases actually come in and are litigated at each level, we might be able to streamline some things.
Thank you. The next question will be addressed to Ms. McEnroe, Mr. Steigoff, and Ms. Hawley. And the question is, judges in Minnesota should follow precedent. When, if ever, would this not be appropriate? Ms. McEnroe.
It's difficult for me to think of a situation where a judge wouldn't follow precedent. But I imagine if there is some constitutional issue with regard to applying that precedent to the facts that happen to come before the judge, that might be an instance where it would be inappropriate to apply precedent. But generally, I would say that that would be extremely rare.
Thank you. Mr. Steigoff.
Does anybody in the audience know what judicial precedent means? Very quickly, it's if the Supreme Court is the final decider on state law, then the Court of Appeals must follow their decisions, and so must the district courts. It's a way of law. It's been a way of law. It should be the way of law, because otherwise there is no law for a judge to follow. Every judge is on his own. And so it's necessary to the legal system. It's necessary to protect your rights, so your attorney can advise you about your case, what's going to happen, how you'll be affected by the law, not everything being a roll of the dice. Thank you.
Thank you. Ms. Hawley.
I think the only time it's appropriate not to follow precedent is when there has been a change in the law. And in reality, that happens almost every legislative session. It's one of a judge's difficult task to keep up with those changes, but often pulling up the same case that you argued as a young lawyer 20 years ago and assuming that that's still the law is not going to be an accurate result for the case. So it's very important to stay up on those changes. I also agree that if there is a constitutional issue that arises, it may be necessary to depart from precedent, but that's really the only time.
Thank you. Mr. Marker.
I think that that a district court judge should follow all available precedent at all times, unless there is no controlling precedent. And in those situations where there is no controlling precedent, the court has to use additional resources to thoughtfully apply the law. But I certainly don't think that a judge should legislate from the bench. None of us are running for legislature. But a district court judge almost always has some sort of precedent to apply to a case. And it's troubling when, as a practitioner, when you see district court judges ignore controlling precedent. That's extraordinarily frustrating, and I think that's not the role of district court judges.
Thank you very much. The next question will be for Ms. Smits, Ms. Brosnahan, and Mr. Jude. And the question is the Minnesota Constitution a living document? Ms. Smits.
Thank you. Is the Minnesota Constitution a living document? Was that the question?
Yes.
Thank you. Of course, the The Minnesota Constitution or the United States Constitution are both living documents. They are constantly changing by increments, by case law, by people that go before the Supreme Court and make arguments to get us new case law. The Minnesota Constitution is living and it is alive today, and I hope that all of you will exercise your right to vote and choose wisely.
Thank you. Ms. Brosnahan.
The Constitution of this state is changes with the time and the mores of the community to the extent that the founders couldn't envision the changing technologies and the like. For example, we constantly, with respect to Fourth Amendment law under federal Constitution, and then as applied through our state Constitution, the mirror provision of it, with Fourth Amendment seizure issues, search and seizure issues, we have so many more issues as with respect to electronics versus just a person's home or the person's self with respect to search and seizure. And so the documents have to change with the time to take into account the changing nature and dynamics of our society.
Thank you. Mr. Jude.
Thank you. And on this question, I disagree a little bit with the previous two responses. The Minnesota Constitution, believe it or not, there are two constitutions in Minnesota. There's a Democrat Constitution and a Republican Constitution in terms of documents. Now, they say the same thing, but that's what the founders put together when we became a state in 1858. They're very detailed. Our Minnesota Constitution is extremely detailed. It's almost like a law book. But there are only two ways to change the Constitution. One is through an amendment. The other is through a constitutional convention. Otherwise, the Constitution is as it's written. And I'm somewhat perturbed when I see proposed constitutional amendments where the question on the ballot does not actually reflect what is added to the Constitution. And in a sense, I see that happening once in a while by the legislature, where they will propose a constitutional amendment that does not reflect what is actually added to the Constitution, but it does not change. It does not get up and walk around. Thank you.
Thank you. The next question will be for Ms. Arnold, Mr. Penwell, and Ms. Hennessy. And that question is, right now, the Supreme Court effectively makes their own rules of conduct and administration. Some have called for the legislature to adopt a statutory code of judicial ethics. Do you think there should be changes in the way the Supreme Court makes rules? I forgot who I called first. Ms. Arnold. Or maybe I didn't.
Thank you. I do, sometimes I hate change, but I do think that that might be an appropriate tool, especially after given Mr. Wurzel's comments here today and his experiences going through these judicial canons, that this would be an appropriate way of handling that system. Obviously, a branch that needs to police itself has to have that kind of integrity to do so. Now, the Bar Association itself and what we as attorneys have to go through under our legal requirements or our moral and our ethical requirements, we do that to a certain extent. I wouldn't necessarily suggest it at this time, but it's getting to that point. So, thank you.
Thank you. Mr. Penwell.
Thank you. I think it's always a bit of a concern